But before we get to that, Mike Davis of the Article 3 Project is going to tell us about where we stand with President Trump's indictments, with the Biden administration's what he calls election interference, and where everything heads going as we move forward into these cases and to election season. So without further ado, Mike Davis. Mike, thanks for taking time to join us today. I appreciate it.
Thank you for having me.
You bet. So you recently tweeted out that Biden is involved in election interference, trying to prevent Trump from getting back in office. Explain what you mean by that.
Well, President Biden had Jonathan Sue, his deputy White House counsel, waive President Trump's claim of executive privilege, something that every president has had going back 250 years to George Washington, to unleash the unprecedented, unnecessary, and unlawful home raid on President Trump to go get presidential records that President Trump was allowed to have under the Presidential Records Act.
And so you believe that this is his way of making sure that he doesn't get on the ballot? Because it's interesting. Initially, when I saw that, I started to think 14th Amendment.
Yeah, I mean, that's also part of their strategy. Look, they impeached President Trump twice for nonsense. They've indicted him 4 times for non-crimes, and you're seeing that this Democrat lawfare and election interference is actually backfiring on them. President Trump is becoming more popular. There are a lot of people who say that they may not necessarily like President Trump's rhetoric, but they're sure as hell not going to let Democrat prosecutors and Democrat judges and Democrat juries and Democrat hellholes like D.C., New York, and Atlanta pick our next president. So the Democrats' next play is they're trying to use Section 3 of the 14th Amendment, passed after the Civil War, to disqualify Confederate sympathizers from taking federal office. That you saw after the Civil War, these Confederate sympathizers were winning the seats in the House of Representatives and undermining the post-Civil War Reconstruction efforts. And so they passed the 13th, 14th, and 15th Amendments, the post-Civil War amendments, and Section 3 of the 14th Amendment disqualifies people who took up arms against the United States, insurrection or rebellion. And that's what they're trying to use against President Trump.
Do you think, just this weekend, there were several more polls that came out that showed President Trump's lead over President Biden growing? And we've now seen that both in the swing states and nationally. Do you think, let me ask it this way, how do you see the 14th Amendment play by the Democrats going down? Is it that they start in one state and then use that precedent? Is it that they just ask for the Supreme Court? I mean, how do you as a lawyer, if you were on their side and said, here's how we could effectively try to implement this, how would you go about it?
Well, they're doing it right now in Colorado. They're trying to get President Trump disqualified in Colorado, which has become a blue state. And so they can set a precedent where the Secretary of State or some state judge can just say, yeah, President Trump committed insurrection or rebellion, so therefore we're going to disqualify him from the ballot. And then they're going to use that precedent in swing states. Here's the problem, that there is already a case on point from 1869 that Samuel Chase, the Chief Justice, sat on this case, and that the ruling is very clear. If you want to disqualify under the 14th Amendment, Congress has to pass a statute related to insurrection or rebellion. You have to bring charges under that federal statute. You have to get a unanimous jury to find him guilty, a judge to convict, and it has to be upheld on appeal. And Congress has passed that statute. It's been on the books for many, many, many decades. And if the Biden administration wants to disqualify President Trump, they need to charge him under that statute. But they know they don't have evidence to charge him under that statute. So now they're going to have their Democrat and Trump-deranged Republican officials around the country try to do this through fiat, whether it's the Secretary of State's fiat or some judicial fiat from some state judge. The Supreme Court's ultimately going to rule for Trump, but this is going to create chaos in our election system.
So I'm glad you brought it up that way, because I remember when that first indictment came down against President Trump, the indictment in New York by Alvin Bragg, the DA there. And I asked lawyers, I said, I don't understand this. It seems as though the statute of limitation has expired. It seems like this was a misdemeanor made into and they said, yes, but in the era of Trump, judges don't care anymore about what the law and precedent would be. Is there a concern that despite everything that you just laid out, that some judge in Colorado says, it's Trump, screw it, I'm just going to kick him off the ballot?
Yeah, I mean, it sounds like this judge is heading down this path because this judge in Colorado has denied like 3 or 4 motions to dismiss uh, based upon the proper interpretation of the 14th Amendment. And look, the Supreme Court, the appellate courts in Colorado, the Supreme Court in Colorado, it's all Democrat dominated now. So the Supreme Court is going to have to step up. That means that the Supreme Court, they have discretionary review. They don't have to take these cases. So these Republican appointed Supreme Court justices are going to have to put on their big boy pants and show a little bit of courage here with their lifetime appointments and their pay protection. They may actually have to do their jobs, and they may have to offend the Washington Post and the New York Times. But at the end of the day, the law is very clear.
Yeah. I mean, again, I look at this as just from a layperson standpoint, and I don't understand. One last thing on this point, because I want to, is in the Constitution, it talks about all these federal officials. It doesn't actually mention the president.
Yeah, I mean, that's another very good point, because is the president of the United States an officer of the United States? That needs to be resolved by the Supreme Court as well. But even if President Trump was an officer of the United States as the president of the United States, the 14th Amendment is very clear. Section 3 is very clear. Section 5 is very clear. The 14th Amendment is not self-executing. Under Section 5, Congress has to pass legislation to give the 14th Amendment effect, and you can't have some bozo Secretary of State in some blue state or some bozo judge in some blue state just decree that President Trump committed insurrection or rebellion and can't be on the ballots.
Right. I want to switch gears and talk about these indictments that are coming down. Last week, in this Fulton County, Georgia case, you saw 2 individuals that had been indicted, Sidney Powell and then this Chesborough guy, a lawyer, also plead guilty. Explain why you think they pled guilty and how big of a deal or not that is.
I think that they pled, and I haven't talked to either one of them, but I think they pled guilty because they understood if they didn't plead guilty to these misdemeanors with the promise of no jail time, their lives would be destroyed by this Fulton County DA, this Fani Willis, this deranged DA, and this Fulton County overwhelmingly Democrat jury pool. So I think that they just said, you know what, we're going to plead guilty to these nonsensical misdemeanors. And even though they're not guilty, they're going to plead guilty just to make this go away. I think it shows that Fani Willis's RICO conspiracy case against President Trump and all the co-defendants is utter garbage. It's utter nonsense. Sidney Powell is supposedly—
Should he worry, though? Should Trump be worried about that? The thing that I find interesting, again, going back to my non-lawyer world here, is both of the people who pled guilty to these misdemeanors were his lawyers. And so how much can they actually say because of attorney-client privilege?
Well, you don't remember, Sean, there's the Trump derangement exception to attorney-client privilege. There's the Trump derangement exception to every constitutional provision, every statute. The rule of law applies to everyone except for Trump.
But so if you're Trump's team and you're sitting back watching these 2 people plead guilty and assuming, I agree with you, I think they jammed them and said, listen, you get convicted of 1 felony, you're going to jail. So, save yourself jail time, plead to these silly misdemeanors and a couple $1,000s in fines. I get that. There's, when you're staring down the barrel of jail time. But should President Trump worry about what they may or may not say?
I don't think so, because no matter what they say about President Trump could not have committed a crime, period, full stop. It is not a crime to object to a presidential election. It's specifically allowed by the Electoral Count Act of 1887. If it were a crime to object to a presidential election, Democrats would be in prison for objecting to Republican wins in 1968, 2000, 2004, and 2016. It's also not a crime to twist arms politically. That's allowed by the First Amendment. And President Trump has been filing motions to dismiss on 2 key grounds. What he did as the president of the United States, including at the outer bounds of what he did as the president of the United States, is covered by presidential immunity, right? So that's number one. And alternatively, what he did as a private citizen is protected by the First Amendment. So this judge down in Georgia may not agree. This could be some Trump deranged Republican judge. But at the end of the day, both with Jack Smith's indictment in D.C. for January 6th, along with Fani Willis's indictment down in Fulton County, Georgia, for January 6th, they're both going to be dismissed by the Supreme Court at the end of the day under presidential immunity or the First Amendment.
So let me just ask you this last question. Timeline wise, I agree with your assessment that these guys are out to get him, both in D.C. and in Georgia in particular. So let's say he gets convicted and he appeals. Does that timeline lend itself that he could have this resolved by the time he becomes president again? Or would this happen while he was president?
Well, so when you file a motion to dismiss under presidential immunity, that is immediately appealable to the appellate courts, and the Supreme Court, if the Supreme Court decides to, again, put on its big boy pants and decide this case. The First Amendment issue doesn't have to stop the case. Presidential immunity stops these cases in their tracks until they're resolved by the appellate court. So I can see these trial court judges denying, like Tanya Chutkan is the Obama appointed DC judge who's looking at Jack Smith's case. There's a Jack Kemp appointed judge down in, Brian Kemp appointed judge down in Fulton County. So who knows how he's going to rule? But at the end of the day, the Supreme Court will ultimately have to take these cases because these cases are so much bigger than Donald Trump. This is about presidential powers and whether the president could be indicted in federal court or a state court based upon exercising his presidential powers, including the outer perimeter of his presidential powers. They're alleging that President Trump ordered his vice president to not certify the election. Well, you can't do that as a private citizen. That's obviously in his presidential powers.
Well, as you said, I hope the Supreme Court orders several pairs of big boy pants. They will need a lot of them based on the number of cases that are headed their way. Mike Davis, thank you for being here. Appreciate all the work that you and everyone at Article 3 does. And again, go visit Mike and his team there because he put out this on Twitter. It's largely financed by him. And so anything that you guys can do to help his effort is obviously appreciated. Mike, thank you.
Thank you very much.